Good afternoon, everyone, and welcome to our webinar to discuss the social media litigation for Illinois school districts presented by Franzik PC and the Franz Law Group. My name is Aristolianis, a partner at Franzik. Thank you for joining us for the next 30 minutes as we provide an overview of litigation against the giant social media companies and the impact they're having in the school setting. With us today is William Shinoff from the Franz Law Group, the attorney and firm leading the litigation efforts for hundreds of school districts across the country, along with my partners Nikki Baser and Michael Hernandez. We partnered with William and his firm in the recently and successfully concluded Juul vaping litigation. We'll have more on that later. Our goal today, and I want to preview for you what we're going to cover. First, an overview of the social media litigation. What's this litigation all about? The goals of the litigation and what we are trying to accomplish and what your expectations can be. What your organization's time commitment will be if you participate in this litigation, the steps to getting involved, how a contingent fee works, and then we'll get to questions. So we welcome your questions throughout the program. You can send your questions via the Q&A box at the bottom of the screen. With that, I'd like to turn it over to William.
Thank you very much, and I appreciate all your time this afternoon for me to present to you on this new matter. So this litigation is a matter that we've been investigating for the past 3 years. While we were investigating, what we were looking to happen was a development of the law, really, on our theory of this case. So as you can see on the screen, one of the main causes of action in this case is a public nuisance theory. So what a public nuisance theory is, and every state has their own version of it, is when a company causes a harm to the community, a public entity, the one that's been affected the most, has a right to go and bring a claim against that company to go and abate the harm, to remedy those issues so that they are responsible for repairing the harm they caused instead of relying on taxpayer dollars to fix that. And when we were focused and looking into the harms of social media, what became very clear is that the public entity that standed the strongest on this issue, that has been affected the most, was the school districts, because the real harm we're seeing is in the youth, and that will fall on seeing issues on our campus on a daily basis. The main defendants in this case are Meta, which is the parent company to Facebook and Instagram, Google, which is the parent company to YouTube, TikTok, and Snapchat. These are the main defendants at this time. There potentially could be other defendants as this litigation unfolds. What this case is focused on is truly came to light when a whistleblower from Meta came and spoke in front of Congress and provided documents to the New York Times, who then went and did their own investigation into Meta. And so what she advised Congress is that her company, Meta, and these other defendants are truly in the business of addiction. They've mastered how to keep children on their platform through their algorithms. Their algorithms is what knows you better than you know yourself. That's what sends you the content on their platforms and sends you all the information. Their whole business model, the way they make money, is by making sure you're on their platform as much as possible. And that's because they get to collect your data, which they then sell. And then they also are advertising to you, and they get money for putting those ads in front of you. But what their own internal documents show, and they've done studies on this, is how do we keep children on our platforms the longest? And what they've learned is that we need to go and push harmful and very divisive content onto them, because that's what's attracting to them to it. But the downside to it, and they've done their own studies and there's been outside studies, is there is an extremely large mental health effect through the content that's being pushed onto them. Before social media, if there was issues on campus of kids bullying each other, it would stay on campus. But now with cyberbullying and the effects of social media, it's a 24/7 issue. And the ability to then go and push the content onto them and making sure that they're liked by their peers has created its own issue. And so as a result, we've now seen an increase in depression, anxiety. They actually also did their own study Meta when they were looking to purchase Instagram. And the biggest issue they saw with Instagram was with the young female population, because what there was being pushed through Instagram, if you're a young female, was body image pictures onto you. And it was creating, we've now seen as a result of that, an increase in eating disorders. And then even the worst thing that we've seen is we've seen an increase in youth suicide. And so what we've seen already this year, and there's been multiple situations that we've seen on the news, and I've spoken with the boards and the districts that have been affected with this issue, is material is posted on the internet by children. It's now regarding another child. It's affecting them. The district then reaches out to these companies to go and take it down because they're dealing with this child and the mental health issues they're dealing with, and they get no response. Or even worse, the company responds and says, well, it doesn't violate our terms of our policy, and we're going to leave it up. And then the child takes their life. And this is now becoming too common of an occurrence. And so that's what we're focused on. Our case is focused on the fact that these companies have created a harmful and addictive product. They're failing to warn about the harms of their product, and they're not taking the appropriate steps as a company in this country to go and protect the children. And so that's the crux of our case. This case is going to be litigated in the Northern District of California. That's where it's been consolidated for one sole purpose. A majority of these companies are located and headquartered in the Bay Area of California. This is a multi-district litigation. So this is not a class action where we have filed one case on behalf of every school district on the country, and we are asking you to join. What a multi-district litigation is the big difference is that we file lawsuits on behalf of every plaintiff in the case. So in this instance, a school district. And how the federal court deals with the influx of cases being filed is they consolidate it into one quorum. And that's because all the cases have the same question of fact and the same questions of law. The damages are the only difference between the plaintiffs, which get dealt with through the bellwether litigation, which we'll talk about a little bit later. But the main purpose of it is when we're dealing with damages that are so high, as in a case like this, we don't like to do class actions. We want to do a multi-district litigation because that gives you a seat at the table. You have your own case, and then you have, as a plaintiff, the right of whether you're going to resolve your case or not if there is any potential settlement. This is exactly the way we handled the Juul litigation, which we just have had successful result with Juul at the end of last year, and we just resolved yesterday against Altria, which those of your districts that were involved in that will be updated on that matter shortly.
It's Mike Hernandez. Let me just add a few items. Just a reminder, this is affirmative action that has been taken by these defendants. And so there are certain immunities that may exist out there that are not, we believe, that are not going to be relevant here because of the affirmative action that they are taking. And as William spoke to the MDL, the multi-district litigation forum that we're using here, in the Juul vaping litigation, districts were contacted by other attorneys seeking to file class actions. We think this is the better vehicle. William has experience in working with this. I've had experience in working with the asbestos litigation. And this is the vehicle that was created because the courts were being crushed by those other Agent Orange and other mass litigations. There'll be individual complaints filed for each district that decides to participate in the litigation, but it will be filed in the district court in California.
Now, what the end goal in this case and what we're trying to obtain in this case is two things. There's monetary relief and there's non-monetary relief. And the way us as attorneys obtain non-monetary relief in federal court is what's called injunctive relief. So injunctive relief is a federal court order requiring the defendants, so in this case, the social media companies, to take steps to make change. And so specifically what we're looking from these companies is a few things. So one is we want a change to their algorithm. So if they know the user is a child and they always ask when someone is joining their platform what age they are, that they're not going and pushing the harmful and divisive content onto them just for the pure purpose of profit. Yes, they're going to lose money by making this change, but we believe that they need to make this change in order to go and address the mental health issues we're seeing. The second thing we want to do is age verification. A lot of these companies go and say that their users required to be age of 13, but they're not doing any steps to go and actually verify that age, which they do have the ability to do. The third thing we want is parental controls. After we began filing these lawsuits a few weeks ago, users started noticing updates to their terms of policy whenever they log back into the platform. They have initially started making a little bit of ability for parents to have control over their child's content. So we want parents to be able to have the ability to go and control the amount of time their child are on these platforms, because what studies have showed just this year is that children under the age of 18, a majority of them are spending over 7 hours a day on the social media platforms, which clearly, if it's a weekday, that's taking into the time of when they're at school. And so time control, we want them to be able to control who they're able to communicate with, because we've now seen over and over again, children being able to talk to adults through these platforms and it leading to issues in the content that they're being seen. Give parents the ability to control it, because one thing we know, we're not trying to get rid of social media. That this is here for good, and there's definitely some positive aspects to social media, but there's some changes that need, and there's legislation that's being done right now in DC, and in certain states have already taken those steps. But this is what's necessary. And then finally, what we're also trying to do is opening up the lines of communication between the school districts and law enforcement and these companies. We don't want any more for these school districts' calls to go unanswered or unresponded to. When there's a request to have posts taken down, there needs to be ability to communicate with them. If there's a threat to the school district, because every threat needs to be taken credible, that the district can find out who that person is, so that the district and law enforcement can deal with that and be able to deal with the fake profiles and all those other things that need to be dealt with. So the lines of communication are going to be important to move forward. So that's the non-monetary relief. Now, the monetary relief we're trying to obtain in this case is to address the 10+ years of harm that these companies have caused in our community. So specifically, what we're going to be seeking is be able to get funding for school districts to be able to deal with mental health issues on their campus, then also educating the students and their parents on social media use and any other the related issues that correlate with that. So there are two forms of our objectives in this case.
Then Nikki, we're going to be receiving questions and questions in the application, so that before we talk about time commitment, we did receive, for example, a question. Well, and I think Williams already spoke to part of this. We're not looking to shut down these social media companies. We understand that districts have various relations with them, from positive communication forums that they may have that you utilize for your students, for your community. We'd like that to continue, so there's no effort to stop that. And then, you may use some of their platforms for your day-to-day work. Again, not looking to shut any of that down. But if there is, for some reason, a communication after you get involved in litigation about or attempt to retaliate, you need to let us know. We'd go to the court right away, because that's a separate issue. Again, the industry should continue. Your relationship with them can continue. So what's the time commitment? Is this like other litigation? You've seen, in one sense it is, in another it's not. So there is a fact sheet. There's an expedited form of discovery that is utilized in this courtroom, and it's a fact sheet. We're anticipating from 1 to 3 hours, similar to limited discovery that you've seen in other cases. You'll want to designate someone. What has happened here is traditionally the superintendent is designated as the representative for the districts in these matters. There may be a secondary person you're going to want to identify. It could be the business manager, could be the operations assistant superintendent, because we'll need to work with someone as local counsel to Raris and I will be working with Williams' team to make sure that all this information is exchanged There may be some documents that you have to produce. There may be some questions you receive from your public, and we'll coordinate with all that. And then the question becomes is bellwether status. Let me talk a little about this. I welcome William's thoughts on this. So through the MDL, through the multi-district litigation process, they have what are called these sample test cases. Let's say there are categories that are created, maybe sizes of school districts, maybe areas of the country. The court's going to decide if the litigation moves forward. The focus here is to try to resolve the litigation. But if we have to move forward, then they identify particular cases that are test cases for different categories that actually get ready for trial. So will you become a bellwether district or case? That could occur. You could voluntarily tell us you'd be interested. Some people are not, because it's a bigger commitment. There's depositions, there's experts, there's a trial that happens in California. And so, but the way that works is after they do the test trials, then they have a better sense of what the cases are worth. And so that's an issue that's out here. There's going to be some costs related to that. And those districts that wind up being bellwether, the results of what they would receive in a settlement or in a judgment will probably be a little higher because of that extra commitment. But hopefully we won't need to go that route. But William, anything else to add on the bellwether status?
Yeah, so as Mike addressed, for a majority of you that would get involved in this, all you're going to have to do is your only time commitment on this case will be filling out the fact sheet, so a few hours. But if you have interest in being a bellwether case, to be one of the test cases that we do, then yes, there's going to be a lot more time involved. The depositions, document production, responding to further written questions. And so there is the staff time that will be involved, but there is financially a larger benefit to your district if there is a resolution. So a good example to give you is Jewel, which we just resolved. One of the districts that were selected was San Francisco Unified. They're not a large district. I would consider them somewhere medium. They should have gotten anywhere between around $800,000 to $1 million based off of the allocation model if they were a non-bellwether case. But because they were a bellwether case and because they went through the process of litigating the case, this is not going to even go into trial. They ended up receiving $12 million. So there is the potential financial benefit to provide you the financial recourse for the time that you put in, but we leave that up to every district of whether they want to go and put in that time. But there is definitely a benefit, and we always would be interested in representing any district that has that interest in doing that.
Let me chime in on the plaintiff fact sheet too. So just to add a little color to it, it's a negotiated, agreed upon questionnaire, essentially. So William and his team and the lawyers representing the social media companies with the sort of under the direction of the judge will decide what is the information that we need to have sort of a common set of facts and to be able to line up these districts next to each other. And that's the negotiated PFS, the plaintiff fact sheet. So for those of you that were involved in the Juul vaping litigation, that was a 1 to 3 hour time commitment. We're guesstimating it would be similar here. We could be wrong about that, but that's what we're thinking it's going to be. But that has yet to be negotiated and will be with William and the other lead attorneys in the case.
We're going to talk a little bit about next steps for the districts on this call, but before we get there, William, a question came in on the substance of the lawsuit that I think is an interesting one. Have you considered addressing the arbitrary age of 13 in the lawsuit? The Surgeon General's recent comments seem to indicate that even 16 is too young for children to be using these platforms. You are muted, just so you know.
Yeah, so that's part of what we're looking into. I mean, that's gonna be all part of the discovery process of why 13. Why was that the age that was decided? And yeah, the Surgeon General's reports only helps our case because those are the studies that will help us show what us as attorneys call causation of how these social media companies directly harm our children. And so that's going to be part of what we're looking into, and part of potentially requesting changes to these platforms of what they're requiring on age. Because as we're seeing now through legislation in different states, so we can go to look at we can go to Arkansas where there's bans going on. We can go to Utah where they are literally now putting the onus on these social media companies to show why they are not harmful to children and requiring further age verification. So there is finally getting of movement on this change, and it's been taking a long time, but we're getting there. But this litigation, as we've seen in other litigations, will help make that change as well, on both in the judicial branch and on the legislative branch.
Great. And we have a question in on bellwether status, excuse me. If we think we have specific instances that impacted students, actual suicide, which obviously we hate to see that written, and a direct threat with guns to a school, for example, is this something that might make us consider participating as a bellwether district?
Absolutely. Absolutely. Those districts that have those terrible stories, those horrific examples, those are the districts that provide the direct examples of the issues that we're talking about. So yeah, that would make the district a stronger case. Absolutely.
All right, please keep sending questions as we go, but we did want to just talk a little bit about the steps to getting involved. So the next step for any district who is interested in participating in this litigation would be to have the board authorize or approve an authorizing resolution. We do have a resolution that we can provide. Attached to that is the attorney fee agreement, and we'll talk in just a second about the fee arrangement. In terms of timeline, at this point, there's no deadline to authorize that resolution and get involved. However, we would really encourage, if districts are interested, that they do get involved either this summer, this still at the end of the school year, this summer, or early fall. I think William can confirm that sort of the earlier you get into these litigations, the better in terms of your, if they are resolved successfully for the school districts, the damages award will be higher for those who have gotten in earlier. And as your recovery gets reduced over time, the later that you get into the litigation. So if this is something that boards are interested in, we do encourage that they go ahead and talk with us a little bit more and go ahead and approve those authorizing resolutions should they want to get involved. But I will kick it to Mike to talk a little bit about the fee arrangement, and then we'll circle back to some other questions that we have come in.
Thank you. So this is not an hourly fee case. This is a contingent fee. To the extent there is no recovery, there will be no fees owed by the district. What we also have experience with working with William, with our work on this, is that the lion's share of the recovery doesn't go to the attorneys. You're not going to get some, $30 check like in the recent Facebook litigation. The lion's share goes to the districts. That's what we're trying to do here. It's a contingent fee agreement. It's a lower than what is normally a standard contingent fee percentage. You will see that in the contingent fee agreement with Williams firm. And then you don't pay us any additional money. We will be serving as local counsel. We will be putting hours in on the case, but we take a percentage of what Williams firm receives. So again, it's a one fee. We work with the court for our percentage and William. I saw a question that came in about, how many districts would be targeted. Our experience, for example, we had 24 Illinois districts that are in the Jewel litigation. We have the final component that's going to be settled soon, we believe. But we think there are many more districts in Illinois, 75 to 100, that have experienced harm in these cases.
Yeah, so the question that had come in, and William, I don't know if you guys have a specific target, was how many districts are anticipated or being targeted to join as litigants. So maybe you could talk a little bit about how many have already joined and what you're thinking and your expectations are.
Yeah, so to give an example, so in Jewel, my firm represented a little over 1,000 school districts in that case. And Jewel, as we ended up seeing, was more focused on high schools and a little bit on middle schools. But with this case, this is a K through 12 issue. With that, we've been working on this case now, started filing these cases, reaching out to districts, I would say, for about a month. We're already at over 350 school districts within a month. That took me over 2 years to get to that number. Our expectation is that it will absolutely be over 1,000 school districts we'll be representing in this case. And as Mike said, we believe it's going to be a lot greater number, larger number in the state of Illinois as well.
Great.
Can I mention costs? As we indicated, to the extent there's no recovery, there's no charge to the district. But there is not only a fee, but there's a related costs that the firms and primarily the lead litigation counsel, Williams firm, have invested in. They've invested a lot of time, effort, and experts and other costs that will be related to the case. That is recoverable from the fees, from the recovery that any settlement includes, okay? There's also some community costs that are associated, for example, with the bellwether defendants and other universal experts that are going to be brought in, because that's what we're going to need. There's already some experts that have been brought in and worked with, but to the extent our experience in Jewel is those costs have been very reasonable, but that is a piece I want to make sure that everybody's aware.
Yeah, and one other thing to touch on the cost portion is just like the fees, if there's no recovery, then the district's paying no fees and no costs. So that's on our firm, that if there is no recovery, then we eat those costs. And based off of our experience in cases like this, and due to the large number of clients we'll be representing, the additional on the cost, you're looking at anywhere between 3 to 5 to maybe 7% additional on top of the fee. That's kind of the norm and the standard. But again, if there's no recovery, then no paying of fees and costs.
Let me address communication too. So with the Jewel litigation, that sort of got rolling with the Illinois school districts in the fall of 2020. And in order to keep you and your boards apprised of what's going on, Williams firm has periodically sending out e-bulletins or alerts. We have been doing the same. During the pendency of the Jewel litigation, we hosted 3 webinars with William, where we provided updates on the status of the litigation, answered questions that people had, and tried to give you as much information and keep you up to date. We anticipate doing the same thing with the social media litigation, regular updates, periodic webinars, and just keeping you apprised of the status.
I'm going to run through a couple of quick questions and then get to some of the more media ones as well. We will definitely share the slides with everybody who has joined and signed up for the webinar today so that you can have them. A question about how to get the board resolution. You will see on this slide the 3 of us from Franzik, our contact information. You can reach out to any one of us and we will provide the resolution to you as well. Question came in, William, is this limited to public school districts, or does the suit apply to private schools? I'll throw charter schools in there as well, which of course in Illinois are public schools.
Yeah, so public schools and charter schools, absolutely. Their causes of action are going to be the same. Private schools can bring a case as well. The causes of action will be a little bit different, but they do have the right to go in and bring a case as well.
Great. Question in on parent responsibility. So how would this lawsuit take into account parental responsibility? Seems based on how phones, devices are paid for, parents should be assuming a chunk of the responsibility since they can take away a device, etc. How are you looking to address this, and what portion of issues are on the companies, I suppose, versus the parent?
Yeah, so since these cases are going to be litigated in California, we do an apportionment of fault. And so a jury will determine how much fault is on each one of these companies and how much does the fault fall on a third party. We dealt with that just recently in the trial with the vaping litigation that we were in trial on. There's always a way you can, they were blaming parents as well for vaping too, saying that these are their child, they're minors, they could have taken away the device from them. That's part of our argument. That's part of their argument, but it's going to be a percentage of fault. And they're going to go and put a percentage. They have the right as a jury to go put a percentage on the parents, absolutely. But our job is to try to minimize that as much as possible.
I think we're just about at time, but I do want to circle back to something that Mike addressed earlier and get folks' thoughts on this, which is a lot of our districts will say, well, we're a Google district. We use all of these products. In some cases, they're a real positive for us. In other cases, we just are, this is what we use. And we're very concerned that if we then sue the district or sue the company, that they will take that out on the district in some way. Any thoughts on that issue? I know, Mike, you touched on it earlier briefly, but maybe just round that out before we end today.
Yeah, William and I have discussed this. It's an issue that we looked at immediately when we started to look at this. And what's nice about the multi-district litigation, you have a dedicated judge in there. And if we think it's going to be an issue, we can bring it up early on in the litigation. Judge, we don't want any retaliation here. But if we have to, William and his firm are committed to going in to seek an injunction. But again, you know, business, there have been these lawsuits before in other cases, in other industries, with the car industry. They don't stop this. They don't try to retaliate. It's part of doing business. We're just going to try to modify how they do business so that the kids aren't being hurt.
Great. Eris, you want to?
Yeah, I think that's it. So first of all, thank you all for participating in the webinar. I want to specifically thank William for sharing his expertise and time. Mike, Nikki, and I greatly appreciate all of you taking the last 30 minutes to learn more about this, as well as your questions and thoughts. If you have any additional questions, if you want the authorizing resolution and the attorney fee agreement, contact Nikki, Mike, or me. Any other questions, reach out, and we'll get you answers to your questions, and we'll move forward. So thanks, everybody. Have a great afternoon.